It's quite clear that every time the Cayman Companies Act was revised, they could have introduced unfair prejudice as a remedy and chose not to do it. And we can't infer any public policy really from that, apart from the fact that obviously the legislature attached importance to keeping winding up. The government and the legislature decided never to introduce a full-blown freestanding remedy, as it has everywhere else. Everywhere else in the common law world, we have separate remedies, but not here.
No, so it's an inference from the absence of reform that you're making.
Well, the Act is reformed all the time, yes. Almost every year.
Yes.
And, you know, the people who work at Maples, the people who work at all the law firms, they know about all these things. They go to the legislature, they ask for amendments. Everyone knows about unfair prejudice. Yeah. Our attention was drawn to it in the CVC case because we didn't have it. So Lord Millett says, well, you don't have it.
Yeah, Mr. I'm not suggesting the inference isn't well-founded. I just wanted to see if it was essentially an inference from the absence of reform.
It's quite striking that there's a refusal to change it.
Thank you.
And because of that, I'm not going to add anything to the public policy argument that's in our case, because you've got it there. But at this stage, what I'm trying to say is that the winding up provision in the Cayman Islands has a great deal of significance, because it's the only shareholder remedy, and it's been deliberately done that way. That's really the point. And you know, there's a distinction, obviously, with everywhere else now, because of Fulham and Tomalugan, we know that unfair prejudice can be arbitrated everywhere else, and it's not been decided that when it's the only remedy, by any higher court, when it's the only remedy, you can arbitrate a winding up petition. The other side's case seeks to paint us as an outlier, as a sort of, the Court of Appeal as a complete outlier, a sort of rogue decision. And it's not, because the reason it's an outlier is because the Cayman Islands is itself an outlier in this sense. Another preliminary point I wanted to make before I get to construction proper is that a number of jurisdictions allow a winding up on the showing of unfair prejudice alone, i.e. not with reference to just and equitable. So the exercise which the court undertakes is not to form an opinion that it's just and equitable in those instances. For example, in the BVI, the Business Companies Act allows you to wind up for unfair prejudice, and I'll give you the reference. It's 2586. In the BVI, winding up order is called appointing a liquidator. In Canada, the same result obtains 2596. And in Singapore, there is also a power to wind up if the court finds the conduct to be oppressive. And that's in section 2161 and subsection 2F of the Companies Act, I think.
What page is that?
I've got to find the page. I'm afraid I lost the reference. But that's significant when you look at least one or two of the cases, because my learned friend relies on BVI, Singapore, and Canada in his schedule. And you can't tell sometimes in those cases. I mean, for example, and I think in the Canadian cases, you can't tell that they're winding up for oppressive behaviour or just and equitable. It doesn't say that.
What practical difference does it make? I mean, I accept that in abstract legal theory, persuading a court that it's just and equitable that a company should be wound up is a different mental process than finding out whether there's been unfairly prejudicial conduct. But
no,
it's not that different, is it?
No, that's not the point, my lord. The point is that when you have a just and equitable provision, the words are always in the opinion of the court. When you have, it's a construction point. These cases, the cases that my learned friend has, he says they're all exactly the same provisions. They're not. I want to construe the winding up provisions, not the unfair prejudice provisions. And so they're practically no different. And when you go to court, same evidence, the point is that those cases don't help you on construction. Yeah. The Singapore reference is 2656 to 2658.
So you accept there's no practical difference in the test for unfairly prejudicial conduct and the test for getting a just and equitable winding up?
No, because what we've done here is we've watered down just and equitable to the point of having at least oppression, not unfair prejudice, but oppression. And we don't have the we have the technicality we've got to show it's just and equitable. But we've gone effectively to the oppression remedy that was in the Companies Act, first introduced in, I think, 48. So if you look at the Canadian cases in my learned friend's schedule, which is at 2085, first of all, on the I think it's in the right-hand column, section 463 is not quoted in its entirety, because that section allows you to wind up not just what he's done here is he's referred to the just and equitable ground, whereas it also allows you to wind up for unfair prejudice. And if you look at the case that he then cites, it's not clear what they've done. They're not construing the words, the phrase that's in our Companies Act. That's the point. You're not getting from that a construction. If he says to me, which he did, or said to your Orchards, I have to say all these cases are wrongly decided because they didn't consider my argument of construction. That doesn't help him because it's not dealing with that issue of construction. And the other cases in the left-hand side of the column on that table are clearly oppression cases. And if you look at the Singapore cases, which are also in that, I think it's 2090, apart from Tomalugan, which we know is unfair prejudice, those other cases don't make it clear whether they're looking at winding up from a just and equitable basis or an oppression and unfair prejudice basis. So I don't have to say those cases are wrong and didn't take account of my arguments. And I'll deal with the other cases in the schedule in the course of my submission. So now I just wanted to get to the construction proper. If I could ask you to look at the Companies Act, which it's just in the same form as you've seen it in the English law, but it helps to start with it. It's 2173. Section 92, the opening words contain a power, but all that power is conditional on the subparagraphs being established, because it ends that sentence with the word if. If relates to each of those subparagraphs that follow, and each subparagraph operates as a trigger or gateway to the power. It gives the court the ability, the permission to wind up. And each gateway, each trigger, each subparagraph represents a statement of fact, a condition which, if satisfied, triggers the power and the opening words of the section. This is obviously so with A to D, and we say must also be the case with E, because the court's opinion is also a fact. And that's the logic of Section 92. Section 92E is a statement of fact upon the satisfaction of which the condition is satisfied and the power exists. It's not possible to satisfy that factual condition in any other way, because it's a descriptive fact. You cannot substitute the opinion of somebody else. The opinion must be that of the court, and that is the statement of fact. The court's role and involvement in establishing these facts can also be seen in subparagraph D, although you can't immediately see it, because D is subject to further elaboration in section 93, and unless you served a statutory demand or you've executed process, the other way to establish inability to pay debts is to prove to the court that the company is unable to do that, to prove it with affirmative evidence, and that's C. But again, these subparagraphs are preceded with the word if, and each subparagraph contains a statement of fact, and C is the same kind of statement of fact as E in section 92. Nobody suggests for a moment that the statement of fact in 93C can be arbitrated. There is a great deal of uncontroversial jurisprudence about what it means for the court to form the opinion in subparagraph E. Quite a lot of this is dealt with in our case, and so I can deal with it quite quickly. But a fairly famous statement of this is in the case of Blériot, which is, I'll give you the reference, it's page 2113, paragraph 45 of our case. The court, you can see the quote there. There's also a fairly, we also know from Lord Wilberforce's statement and what was said about it in Lau and Chu, that the concept of just and equitable is itself not settled. It's something that is fact dependent. It could change, it could be increased. We were too timid in applying it, you know, that sort of line of dicta. But on top of that, we have what the court does when it forms the just and equitable opinion. It makes an inference of law on the facts, the words of the widest significance, and then if you go over the page 2114 to paragraph 47, court's allowed to rely on any circumstances, and there's Locke and John Blackwood. You'll remember Lord Shaw saying the decision depends on a sound deduction of all the facts of the case. No general rule can be laid down as to the nature of the circumstances which have to be borne in mind in considering whether it is just and equitable, and into limiting conditions imposed so that limiting conditions imposed so that the granting of it is in the discretion of the court. And then there's a quote from the Northern Ireland Court of Appeal. And in that context, you have regard to the form of pleadings of petitions. Petitions are not like, we don't have the CPRs here. We still have the RSCs, and we're quite happy about that. But we have the overriding objective, which is helpful. But we don't have in petitions, the rules specifically say you want a concise statement of the grounds, which is rather old-fashioned, and we would apply Refields, and Refield says you have the heads of complaint and you ensure that you plead enough so the other party isn't taken by surprise. But that means it leaves the court quite a lot of scope at the hearing of the petition to look at all sorts of other facts. And then we refer to the partnership dissolution cases, which of course are very different because partnerships are normally determinable at will, and because, as Lord Briggs pointed out yesterday, the liquidation of a company is very different to dissolution of a partnership. But when they've interpreted the just and equitable ground in Section 35 of the Partnership Act, they explain it in similarly broad terms. The response conduct had to be looked at as a whole in context rather than a series of individual breaches, salami slicing, just as a balancing exercise in the petitions for the companies, the court's discretion also involved looking more widely at the applicant's own contribution to the situation. And then we come to the bit that makes it most difficult for an arbitrator to deal with this, which is that decision has to be made at the trial of the petition. It's at the trial that the court has to do this balancing exercise. It has to have this wide survey of facts, that anything needs to be taken into account just to deal with Section 92E. The references to that are in the case, I think, at page 2115, paragraphs 51 and 52. In Lau and Chu, which Lord Briggs was, in which Lord Briggs gave a judgment, a speech rather, it's at paragraph 51. There's a case called Re Fields, which I might just show you because it's striking what it actually happened, and you can see, in fact, what happened. Re Fields is at page 4575. And if you go to 4580, you can see between letters E and F that Mr. Justice McGarry makes the point that the court has to be of the opinion, is of the opinion, that has to be done at the time of trial. And then if you go to page 4581, he deals with what happened in the case. That one of the brothers, and this is a winding up of a company that was owned by two brothers, Ian had an epiphany during the trial. He realized that he behaved badly. He said he'd never do it again. He'd learned his lesson from cross-examination. And then you see the judge dealing with it. According to the question for me, just above D, is whether as matters stand today what has been alleged in the petition proved before me makes it just and equitable. Whatever grounds Ian may in the past have given Brian for the presentation of the petition, I have to decide the case in the light of the evidence now before me. This includes the oral evidence of Ian and Brian. He says he likes the evidence of Ian just above E, and then he says Mr. Settle just above F very properly stressed that Ian's change of attitude was at the 11th hour and that he'd given no hint of it before giving his evidence. It was, he said, a delayed repentance with last-minute concessions. I accept that and the criticism of Ian that it implies, but I also accept Ian as a witness of sincerity, and if repentance is genuine, it's not nullified by being tardy. So that's an example, a vivid example, of things that happen after the presentation of the petition and before the hearing. And Lord Briggs gave the example of, you had an award and they've done it again, because after the presentation of the petition, often the behaviour continues, and there are more facts that come to light before the hearing that are relevant. And that makes it difficult. Well, if you accept our case, that it's the court that has to make the winding up decision, the court that has to notionally give the opinion that it's just and equitable to wind up at the very least, it's very difficult for someone to do that 6 months before the trial. So it immediately introduces a problem with arbitration in the way these sections have to operate. The next point I'd like to make about the way in which winding up works, or just and equitable, is that you're not adjudicating on claims. The judge thought I had to prove a contract for the understanding, and he thought he made a mistake about the breach of duty. I think I told you yesterday. But that's not the point of just and equitable. That's not a cause of action. There's no contractual claim or tort I have to show. As a matter of fact, we've shown breaches of equitable duty because the director's fiduciary duties, because we want to show that there's a lack of probity. But lack of probity is a broad concept. It might, for example, be the case that the arbitrator concludes a year ago, well, there's no lack of probity, but because the conduct, although bad, hasn't been so significant, and then a year later that it's repetitive and it's continued, and the court says, well, I think it does rise to lack of probity. What do you do then? You have a dispute about that, goes back to arbitration. So that's important because you're dealing with these protean concepts. It's the opinion of the court at the date of the trial that matters, and as Lord Justice Patton says, the arbitrator can't arrogate that exercise to himself. He can't he can't form bits of the opinion. It's the opinion of the court that matters. And if it's an opinion, it has to be something honestly, genuinely held. It can't just be something that the court adopts from some other source, we say. My learned friend then argues that, well, any reference to court can be substituted with a reference for an arbitrator, and that is based on two submissions, effectively. First, case law, and secondly, the 2012 Act. So I just quickly wanted to deal with the case law. The reference to court, the first point I'd like to make is adopting a point Lord Briggs made yesterday. It depends, obviously, on the context, the statutory context, whether you can do that. The reference to court may not be so easily interchangeable in every case, and we say, when you look at Section 92E, clearly is not, because it's a statement of fact. Whelan's, which is at, I think the relevant passage is at page 4354. What was said in that is that the submission to arbitration gave the arbitrator the same powers as the court had, impliedly. And so the court had the power to order contribution, payment of contribution, or could calculate interest. And if you look at the passages 4354 to 5, he deals with President of India. Same point made quite clearly in President of India by Lord Brandon, at the bottom of 4354 and top of 4355. But that isn't something that the courts the parties can give to the arbitrator, the power to form an opinion, to get to the point of exercising that power. And in Fulham, which is also relied on page 3756 at paragraph 77, and perhaps
sorry, the reference again, please, Mr. Lear.
It's 3756 at paragraph 77, and in Lord Justice Longmore, it's 3761 at paragraph 96. And they're dealing with the exercise of a power again, and not with the reference to court in a descriptive statement.
I'm sorry. Please just show me that paragraph in Lord Justice Longmore.
It's paragraph 96. The fact that statutory power, which a court would not have at common law apart from the statutory provision, is given to the court doesn't mean that an arbitrator to whom a dispute is properly agreed to be referred doesn't have a similar power.
I'm sorry, where are you reading?
Paragraph 96 on page... Sorry.
Letter G.
Yes, letter G, I'm so sorry. And he refers to Whelan's.
And you're contrasting that with this case?
I'm contrasting it to this case because in all these cases, the court is... what's happening is that the arbitrator can exercise a power which in the statute is given to the court. But in this case, what we're dealing with, in none of these cases that was this the case, we're dealing with a mention of the court in a descriptive statement of fact. So it's a subparagraph E of section 92. And there's another reference to the court in the opening words of section 92, but that's a power. But the subparagraph E is simply the state of the court's opinion, like the state of a mind's digestion. Same sort of thing.
In the light of all the circumstances as it played the trial.
Yeah. I mean, once you know what the jurisprudence is, about how you form that, how that opinion is formed, then you can see how difficult that is for anyone else to come in. But it's not the case that you can substitute, there's no case that says you can substitute an arbitrator for descriptive reference to the court.
Well, you could, yeah, I mean, you could create by contract a jurisdiction and an arbitrator to decide whether there had been unfairly prejudicial conduct, and to decide whether, for example, a buyout was an appropriate form of relief. But you couldn't, by contract, create a jurisdiction to wind up a company.
Precisely. Yeah, that's precisely right. Then I wanted to just quickly deal with the reliance on the Arbitration Act. It's now all the things that were passed as law in Cayman are now called acts, just by the way. Change in the Constitution, and you'll find that at 2169, the relevant provision, section 26. 2 was being relied on. We find reliance on the arbitration law difficult. Now, just let me explain why we say that. But 2165, section 3, which I know you looked at yesterday, specifically provides that the Act only applies with the seat of the arbitration is in the islands, and 2, it applies to arbitrations under any other enactment, which must mean a Cayman enactment, and this is neither. So the Act doesn't apply, and the Act doesn't, on the face of it, become an aid to construction of the Foreign Arbitration Awards Enforcement Law, which is the product of a convention, the New York Convention, separate. And we notified the UN committee, the UNCITRAL committee, of the content of our law to comply with the convention. So suddenly to take a later piece of legislation and to use that to construe the Foreign Arbitration Awards Enforcement Law seems odd, we would submit, and not correct. As far as it helping you with public policy, what it does do is, for example, it shows you what we have the statement in section 3.3 at page 2166 of the objectives of arbitration, but that's, you know that. I mean, it's also in the 1996 Act, this very same provision. It was the Saville Committee and the other committee that decided that we should have this statement at the beginning of the legislation. Very helpful. And I draw your attention to subparagraph A. I'll make some observations about that in the context of procedural complexity and so on. But you can see that might be helpful. But what you get from paragraph 26 2, apart from a technique of construction of other legislation, it doesn't really help you. I mean, in Fulham and in Whelan's in those cases, they apply it in a certain way. But it's not a mandatory provision. It's a question of construction. And that's not a matter of policy. That's just you can't impermissibly use that later legislation to construe the earlier legislation or to construe the Companies Act, which is what this really ends up doing. But otherwise, as I say, Section 3 is helpful.
Well, you're right to say that in terms, the 2012 Act doesn't cover a foreign arbitration. But is there any policy reason to have a different approach to the relationship between the arbitration and domestic legislation in a foreign arbitration from that which is applicable in a domestic arbitration?
Well, I accept that you can have a rule of construction, just as a matter of common sense, that when the parties choose an arbitration, when they are dealing with statutory provisions which refer to the court, they impliedly give that power to the arbitrators. That's what Wheeling says. I accept that. But that's to deal with powers. What I don't accept is that this is a mandatory rule for you. It's a rule of construction when you're dealing with arbitration agreements that covers, you then imply that the arbitrator has the powers of the court. But I just caution you to, before you start applying the 2012 Act, to interpret the other law and getting public policy, which you don't need for this purpose, in order to do the exercise which you do when you're looking at the scope of the arbitration agreement and whether or not it encompasses courts. But my main submission about this is that...
How legitimate is it to look into the 2012 Act if the objection to an application for a stay under Section 4 is public policy?
Yes, I completely agree with that. Yeah, and to the extent that I've got my public policy arguments, as I say, I'm not adding anything that's not in my case. So I don't want to be drawn into using my time up for that, if that's all right. We then get to the other aspect of the winding up, which is, again, if I ask you to look at the Companies Act, and if you go, you've seen the opening words of 92, which give the power to wind up. Section 95(1) contains all the Victorian powers. It's at 2175. I mean, I think this is pretty much the same as the Victorian legislation. 1 and 2 is something that we introduced. The Cayman's introduced, and 3 is the alternative relief that can be given. Now, just assume for a moment that the powers in Section 92 and 95 are powers which can only be exercised for court. I'm going to come to that in a moment, but my submission now is that the nature of the task that the court has to perform when it exercises its discretion whether or not to grant any of these remedies, in other words, make a winding up order, etc., leaves very little room for arbitration. When you combine the exercise of the discretion at this stage with the need for the court to form its own opinion as to whether it's just and equitable, it just doesn't really leave any matters to be determined by an arbitrator. There's just no scope for it, because I'll show you the cases about how you deal with that. Cases make it clear that before the court exercises the powers, and this is quite apart from forming the opinion, it must have regard to all the relevant circumstances. And in fact, there is a pretty clear statement to that effect, if you don't mind me mentioning you again, Lord Briggs, in Ming Siu, which was a recent Privy Council case. The relevant reference is at 4720. And your comment is at paragraph 18. In relation to the exercise of discretions. This is in relation to an unfair prejudice BVI remedy, but it's a valid statement in relation to that. And if you don't accept just on that form because it's unfair prejudice, a clearer statement is for the purposes of just and equitable petitions is Walter Jacobs, which is mentioned, but it's at 5286. And the relevant passages are 5292 to 3. It's dealing, you can see at 59290 is dealing with, this is a public interest petition. And if you go over the...
I'm so sorry, I lost your page number.
5292.
Thank you.
Which letter?
I'm just finding it because the screen's not as quick as my leafing through the bundles for myself.
Certainly, thank you.
5290, you can see the heading public interest. Council criticised the reasoning on 2 grounds. Considering whether or not to make a winding up order, this is at I, the court has regard to all the circumstances of the case as established by the material before the court at the hearing. Normally that will involve the court faced with a petition presented by a creditor or a contributory, considering primarily the conflicting interests and wishes of the opposing parties to the petition, whether creditors or contributories or the company itself. The court will consider those matters which constitute reasons why the company should be wound up. So you look back at, for example, why you thought it was just and equitable, and those which constitute reasons why it should not. The court will carry out a balancing exercise, giving such weight to the various factors as is appropriate in a particular case. And if you go to 5294, just above letter B, the court's task in the case of the so-called public interest petitions, as in the case of all other petitions invoking the court's winding up jurisdiction, is to carry out the balancing exercise described above, having regard to all the circumstances as disclosed by the totality of the evidence before the court. Respective of all such petitions, whoever may be the petition, the court has to weigh the facts to point to the conclusion that it would be just and equitable to wind up the company against those which point to the opposite conclusion. So pausing there, the very exercise of exercising the powers is bound up with the exercise of forming the opinion that it's just and equitable. And then this goes to the point I'm just about to come to. It is to the court that Parliament has entrusted this task in all cases. So,
obviously, you'll be coming to this, but I just flag it up that what you've said so far isn't inconsistent with some of the relevant circumstances being determined by arbitration. For example, in this case, was there an understanding between the shareholders as claimed? Has one of the shareholders acted in breach of the undertaking, of the understanding as claimed?
Oh no, what I accepted yesterday, my Lord, was that it's not, in a practical sense, impossible to have the disputes of this kind resolved in arbitration. I mean, if you're asking me whether can an arbitrator sit down and decide these things, I couldn't say he couldn't. One of the arbitrators we had was the judge of the Court of Final Appeal, Robert Tang. So, we obviously they can do that. The point I'm making is that the statutory language leaves very little room for anyone to do that, because it's the court that has to form that opinion. And it may be that the court can hive off one issue. That depends on whether or not that's a matter in itself. But we'll come to that. Mm-hmm. But for the moment, if you accept, and I'm just about to turn to it, if you accept that the court has to exercise the final powers, that it can't be an arbitrator who makes these orders, then you can see from what I've just shown you, Walter Jacobs, and if not Lord Briggs's earlier comment, that involves the court performing a fairly broad exercise. It needs to go into the same facts as it had on the just and equitable petition at the date of trial, and it then also needs to review other things like the attitude of other people to the petition. So the court has quite a big role in a winding up petition to perform at the date of the trial.
Mr. Lowe, there'd be nothing to stop with that in what I would call a two-shareholder just and equitable dispute. I'm not talking about a creditor's petition here. The shareholders coming to court with a statement of agreed facts and asking the court to form a relevant opinion. It wouldn't exclude the court looking at other matters, but there'd be nothing in principle wrong with the parties agreeing, at least as much as possible, the facts upon which they ask the court to resolve the do we wind up question.
Well, do you remember in Bird Precision Holdings, the court, they tried to settle the relief that the court had to give, and the court has to satisfy itself that the petition is well-founded.
Yes.
And it may be that they can restrict the evidence that the court has to seize on that occasion, but they didn't do that in Bird Precision. They didn't come up with this agreed statement of facts.
I mean, it's not uncommon for something quite like pleadings to be directed in a petition of this kind, and the court doesn't go behind, for example, an admission in the defence, if you want to call it defence, of a fact alleged in the particulars pleaded in support of the petition.
Yeah, but
if that's right, why can't the parties have an arbitrator determine the facts, so that what the court gets, if you like, is a presentation of agreed facts, not in the sense that the parties have agreed the facts, but the facts have been agreed by a person whom the parties have appointed for that purpose?
yeah, I'm really not. This isn't an argument about practicality, because I conceded, and I.
No, I'm not.
You know,
it's a legal question.
Yeah, I mean, in terms of the legal question, what I'm suggesting is that the power, and I'm coming to the power aspect of it. Certainly, the opinion is vested in the court. The power is also vested in the court. And if it's vested in the court, and the court has to make the decision, how is that going to happen in your lordship's example, when it's looking at whether it's forming its own opinion, and then having regard to that, and then having a statement of fact, or does it not do that? Does it form the opinion purely on the statement of fact? It might do, but it's still got to be the court's opinion, not the arbitrator's. And if the court's going to form that opinion, and in exercising the powers has to look to that opinion, well, that's not something the arbitrator under the statute can do. That's all I'm saying. I'm not saying that, and I completely accept that in terms of what could happen practically, what arbitrators can do, they can resolve these questions. But the question is whether the Companies Act provides for them, allows for them to do that, when it's clearly not allowing for them to form the opinion and deliver it to the court. The court has to form that opinion. And in exercising its discretion, the court has to have regard to all the matters it had regard to when it exercised that, when it formed that opinion, as well as other things.
I'm sorry, just for my benefit, could you please just clarify what you're accepting when you say that arbitrators can decide these questions?
I don't mean legally it can. I mean in practical sense. If you went to Robert Tang and said, "Can you decide this for us?" No problem. I mean, he's an experienced tribunal. You know? And so I think the other one was also very experienced, the other majority. So from the point of practical possibility, arbitrators can decide all these corporate governance disputes. The question I'm addressing is really whether the Companies Act leaves any room for that.
Yes, well, could I probe you a bit more on that, going back to Lord Briggs's questions? Because if you're saying that the requirement in the statute that the court has to form an opinion means that the court has to form an opinion on all the facts, how is that consistent with the parties presenting a statement of agreed facts or admitting, as Lord Briggs says, certain things that had happened? Are you saying that the statutory scheme doesn't allow these agreements on facts?
Well, I don't know. I mean, I've never seen that done, frankly, in a winding up petition.
No, but this is a matter of law.
As a matter of law, I mean, if the court has to form an opinion and it's been given a statement of facts, and those are all admissions, for example, on both sides, it might be content to do that.
Yes, but if that's the case, why in principle can't the parties refer to someone else the decision of these facts and be bound by that party, that arbitrator's decision that those are the facts to go before the court when the court forms its opinion?
And the court still has to form its opinion.
Oh yes.
And the court. I mean, if the court forms a genuine opinion, then it forms an opinion. It has to do that by reference to all the facts. The parties, if the parties haven't got enough facts, the court can call for more facts.
I'm not looking at that. I mean, you've got a separate point that the arbitration decision will be taken at a certain date, and the court will be applying its mind to circumstances at a later date. But what I'm probing is the earlier stage. Why in principle, if the parties can agree facts and give them to the court as an agreed position, why can't the parties equally give an arbitral determination as an agreed position on those facts?
Well, I don't see why they can't agree. They can't have an arbitral determination of a fact and hand that to the court. But the court might not agree with the evidence. It might not agree that the inference of law is the same as the arbitrator makes. That's all. So the opinion in the end, my point is that the opinion in the end has to be that of the court. I can't say that the court can't be assisted by a salami slicing of issues, but that depends. And what you have in mind there is that the court is going to do that the matter is actually, for example, you could give the arbitrator the matter of whether the petition is just and equitable. It's an inference of law which you can't do.
Well, I'm thinking more of the points that Lord Reid was mentioning to you.
Yeah.
Why can't a decision by the arbitrator that a party had breached the shareholder agreement, why can't that be a matter that the parties have agreed the arbitrator will determine, and that matter is an agreed position before the court once the arbitrator has made its ruling? I see the difference about the just and equitable decision, but
Yeah.
I'm looking more closely
Yeah.
at matters 1 and 2 of Mr. Kimmons's case.
I see that. If you pass up the matters, and I've got to get to the matters issue.
Oh, yes.
If you can pass up the issues like my learned friend does, and say, well, there's nothing in principle why this is not possible to be arbitrated done all the time, then of course the answer to all these questions is yes. But if the matter is not to be passed up like that, if the matter is whether it's just and equitable, whether that is actually if you adopt the Tanning test, which I suggest you should adopt, then you can't do that. If you pass up the petition into an infinite number of small questions and ask yourself, is that something an arbitrator can decide? You'll always say yes. And that's the beauty of my learned friend's case, because he puts it like that, those 5 matters, and at least 3 of them, you can obviously arbitrate as a matter of fact. But the big issue between us, and my learned friend didn't want to go into it, but that's why we raised it. The big issue between us is what's the matter?
Yes.
And I'll come to that too.
Yeah. So as I understand it, you're accepting that if matters 1 and 2 could be hived off, then an arbitrator's decision could be a factor that could be a determination which the court was faced with as if it were an agreed position of the parties.
Yeah.
But you say that the key issue isn't arbitrability, then it's matter.
Well, if I'm right about matter, then I have to just show you that certain bits of the petition are non-arbitrable, and then the whole matter can't be arbitrated.
Yes, I see. Thank you.
So your position, Mr. Lowe, is that you challenge the premise of the disaggregation of issues or matters. You say it's just not capable of disaggregation at all.
Absolutely, that's exactly what I think. Yeah.
Yeah, thank you.
And I do that on the basis of Tanning, which you asked on a number of occasions to be shown yesterday. And my learned friend said he wasn't making this submission, but actually it's the key point. Can I just
just before you leave this, can I just check another thing with you?
Yeah.
You're not saying, are you, that the court, in a contributories petition, where there are only 2 shareholders, has some separate investigatory role of itself? It takes the facts and the factual disputes as handed to it by the parties, subject only to advertisement at the almost end of the day. I mean, we all know cases where the court hears the parties, decides the case on the basis of the materials put in front of it by the parties, but then orders the petition to be advertised just in case any other stakeholders want to come in and object.
Yeah, the sort of refields kind of case.
Yes.
I mean, this case is actually quite unusual in itself because you've got, I mean, it's a joint venture case, but
Yeah.
not unusual in that sense. But there's another case in the bundle which that lot are on the other side of, which is called Tianrui, or China Shanshu. You've heard that mentioned? Yes. Tianrui is a listed company that owns cement clinkers in China. It's got lots of other shareholders. And the allegation is that the controlling shareholders and directors issued shares that diluted my client's position. If there's no arbitration clause in that, but if there were, there would be lots of other interested parties.
Yeah.
And it'd be much more important to investigate the cause of the company's failure. So we are in one extreme of it. But of course, you're being asked to decide this question for all just and equitable petitions. You have to bear in mind they're not all like this. You know, the arbitrability point, if you decide it in general terms, we're not all like this. We're not all just two-party cases.
Well, we are having to decide this case.
Absolutely.
Which is, I think, at the moment at any rate, a two-party case.
It is, and if you look at the Tomalugan first instance decision, he says, well, some cases they straddle. I mean, it's actually quite a good solution. My own friend says it's really impractical, but he says some cases straddle arbitrability and non-arbitrability, and then we would, on his scale, we would come into the more arbitrable one because there's just two of us. And you remember in Tomalugan there were a whole load of other people who weren't members of the party to the arbitration agreement.
But in this case, as I understand it, Mr. Justice Kawali has made an order that this is to be dealt with as a two-party case. Yeah. Which hasn't been appealed.
No, and it hasn't. It wasn't appealed. It's made by consent.
Right, better still.
Yeah, even better. Yeah.
So it's common ground that we're dealing with, at any rate at the moment, with the two-party case.
I can't really say anything else, can I?
No. But, I mean, what the question I'm putting to you that comes out of that is that if it is that kind of case, then the court deals with it as an adversarial case between those two parties on the basis of such arguments and evidence and facts as are put before it by the party. It doesn't have a roving commission of its own.
No, no, I accept that. I accept that. But on the other hand, it may well be that you know there are other circumstances which bear on making the order, and it may well be that after the arbitrator's made his award, and this is the timing point, which is always going to cause difficulties for an arbitrator. We come along and say, and we have done that. They've done it again, and then that's in dispute, and we go back off to arbitration. So, I mean, I'm going to deal with what I call procedural chaos and remedial impotence when I get to it. But I mean, that is chaos, bad chaos, because I'll show you why in due course. I mean, we had a 4-year arbitration. We'll have another one. And if the arbitrators say, well, that doesn't rise to...
but you can I just also check? You didn't raise in the arbitration, which has already happened, the grievances which form the basis of your petition, did you?
No, we didn't, and I'm sure my own friend will make something of that. But we remember we had the Court of Appeal saying that we could have them dealt with.
I completely understand that, but forgetting where you'd got to here in the Court of Appeal, would there have been any reason in principle why you couldn't? We probably could have done. We may have had to consolidate, and you can do that. You can do an arbitration consolidated. But the fact of the matter is that we thought, in good faith, that we were, we didn't need to do that. No, I understand.
And it may be important when we get to the question of discretion. Can I very briefly mention to you a few authorities why we say we're on good ground in terms of authorities and saying, and it may not be disputed, but you remember my learned friend says that matter 5 can also be arbitrated? Do you remember he said that? I didn't actually show you a case, but the cases that say you can't do that is Fulham, at page 3756, paragraph 76. Warren was right in saying that. And then there's Hydrox at page 5721, paragraph 164. Court can't, the court, with the exception of the part of the present proceedings which involves the court forming an opinion as to whether plaintiff is entitled to winding up questions of fact and law, can be arbitrated. So again, he says that's a matter for the court. And Quicksilver, which is a decision of Mr. Justice Harrison, Hong Kong, 6098, paragraph 14, makes the same point. It's never, I mean, my learned friend, if he says matter 5 can be arbitrated, I think it's going. I thought that, I misheard him. I thought that's what he said yesterday. He thought even matter 5 could be arbitrated. But on that basis, the submissions on the power are what they are. I mean, the powers, I say, have to be exercised by the court. The court has to have regard to a number of things, and I don't need to repeat it.
Just one other small detail. Mr. Lowe, you said, I think, well, we didn't, in perfect good faith, raise our complaints in the arbitration because we had the Court of Appeals decision in our favour. Is that right in terms of timing?
Yeah.
Well, you got the Court of Appeals decision in your favour before the Chinese arbitration even started?
No, the Chinese arbitration started shortly after the petition was issued. Nothing much happens in the arbitration for quite a while, and this has been a long time coming on for hearing.
Yes.
And if we'd known that we had to do it, we would have done it much earlier. But we maintained that the judge was wrong where he dealt with it. The Court of Appeal agreed. We could have. can't remember when the decision was.
The Court of Appeal's decision was April 2020.
Yeah, and the arbitration award was handed down 2 years later.
Yeah.
So we could have started, could have joined. The discovery exercise would have been horrendous because it would have needed to have been dealt with all the related party transactions. We got leave to appeal in February 2019. Anyway, we did embark on an arbitration where we resolved quite a lot of the affirmative defences against us. I mean, that's
Yes.
Yeah. Can I just quickly deal with some of the cases that have looked at the question of construction of the just and equitable limb, if you like? And they start off with the partnership cases. Quite a, I obviously know the health warnings about that, but page 4660.
I beg your pardon, in the light of the discussion that's taken place this morning, could you tell me, please, the propositions that you're going to derive from these cases?
Yeah, the proposition from these cases is that the authorities I rely on support the proposition that a court has to form the opinion and can't delegate it to an arbitrator. I mean, that's a point I've made on construction, and I'm just going to show you a couple of cases quickly that seem to support that. The partnership case, you remember the partnership statute has much the same wording. The first case is at 4660. It's a case called Joplin and Postlethwaite. This was a partnership where Postlethwaite was an inventor, and the purpose of the partnership was to promote the inventions. At page 4661, you can see left-hand column, clause 32, about two-thirds of the way down, is the arbitration clause in the partnership deed. And there was an application to stay, because it was for a term, this partnership, there had to be an application to wind it up, and there's an application to stay on the basis of that clause. And if you go to page 4662, about a third of the way from the bottom on the left-hand column, you can see a passage that begins, but what power has the arbitrator to say that the partnership shall be dissolved? In the left-hand column, the words are arbitrator dissolved. If you look for those, you can see the passage. The clause doesn't give him any such power, so it says it's not in the partnership deed, and then you can go down a few lines to, therefore, the main question in the case, whether or not the court will dissolve the partnership against the will of one of the partners, is a matter which cannot be referred to the arbitrator. It would be ridiculous to say this action and let to stay the action and let the arbitrator make an award that, in his opinion, the partnership ought to be dissolved, and then come back to the court and say, you must act on the award of the arbitrator and dissolve the partnership. The court would not act upon it, and in my opinion, the court should not do anything of the kind. The question whether or not the partnership should be dissolved is one which is eminently for the discretion of the judicial tribunal. No other power can say no partners who have entered, and so on. This is a thing that can only be done by the paramount authority of the court. And then it goes to the Court of Appeal on page 4. This is Mr. Justice Cage. Goes to the Court of Appeal on 4663. And in the judgment of Lord Justice Cotton, about 10 lines down the left-hand column, you can see, but he determined not to stay the plaintiff's action. I think he was right. I doubt if this matter comes within the clause, but even if it does, I doubt whether the arbitration would be a good form. So he deals with it as a matter of discretion, and Lord Justice Bowen similarly says in the right-hand column at the end, I think Mr. Justice Kay was right, but above that he says he deals with it as a matter of discretion.
That wasn't a case of a compulsory stay, was it?
No, because the 1854 Act was a discretionary stay. Yeah. But so if you have a discretion anyway, the Court of Appeal deals with it on a basis of discretion, but you can see that Mr. Justice Kay clearly didn't. He dealt with it on the question of construction. And then you have another case called Olver, which is at page 4865. Decision of Mr. Justice Roxburgh. And he refers on page 4867, this is another partnership dissolution, to Joplin, and he says, refers to the Court of Appeal. Then another case, which is a decision of Mr. Justice Chitty, but it dealt with a different ground of dissolution. And he says on page 4868, at any rate, Mr. Justice Chitty didn't avert to difficulty which troubles me, namely the difficulty of transferring to the arbitrator the power expressly conferred upon the court of deciding not what the facts are, but whether on the facts as found it is just and equitable to decree a dissolution. And then he says at the end of the next paragraph, it appears to me that the dissolution which involves the exercise of discretion, which may involve the appointment of a receiver, is again a matter which is more convenient. So he's dealing first of all with the construction of the just and equitable ground in the first paragraph, and in the next bit he says again, in other words, the exercise of the power, which is how I addressed your lordships, first of all about just and equitable, and then the power, the exercise of the power. So he seems to come to that same conclusion. The learned friend referred you to a case called Phoenix and Pope at 4934, and he said that was a decision of Mr. Robert Goff, who of course is very eminent. This is actually Reginald Goff. You may remember Robert Goff didn't become a judge till 1975. I checked that. I thought it was a different Goff. Anyway, there's no worse to that, but he deals with... sorry. One didn't become a Lord, that's the difference. 4938, he deals with the cases of Mr. Justice Roxburgh. He starts dealing with Joplin, and he goes through. I mean, I'm afraid this isn't. It's not particularly concise. 4939. There's mention of Mr. Justice Kekewich and how he deals with Joplin, and so on. And as it goes on page 4940, there's a Court of Appeal case. Lord Justice Linley seems to think it was all a matter of discretion, and that's how he deals with Joplin. And then the judge eventually finds that, and this is at 4942, between A and B, that it's too late now, and he has to accept the Court of Appeal that it was a matter of discretion. But if you look at and he also says, which is, seems to be against his instinct, this decision, because 4938 at letter F.
What was Mr. Haines' argument?
His argument was my argument.
Right.
And if you go to 4938 at letter F, he says, if the matter were res integra, I think I might well have accepted his submission, so I feel the force of it, and I also share the difficulty to which I will later refer, which Mr. Justice Roxburgh expressed in Olver. Hames said at letter D, the arbitration clause can never be wider than the agreement, and therefore the arbitrator can deal with dissolution only where the partnership agreement expressly allows for it. You remember that in the Joplin case, Mr. Justice Case starts off by saying it's not a power given by the arbitration agreement. So Hames's point is, if it's in the arbitration agreement, fine. If it's not, then the arbitrator can't deal with it because it's a judicial power. He relies on Olver, and the judge says, well, if it hadn't been for all these other cases, I would have accepted that. And then you get up page 4942, he says, in my judgment, therefore, it's too late now for the judge in first instance to accept Hames's argument, because in the Court of Appeal it's been said to be a matter of discretion. But the point about these cases is that they show the argument of construction that's really never been disposed of against me. It's always been, it's been accepted by all the judges who looked at it, that there is a problem of transferring the job that the court is given in the just and equitable paragraph to an arbitrator, because it's, and I say that's because of construction. There's a case called Seed Coatings, which my own friend threatened to show you, which I will show you, which is a just and equitable petition. It's at there's a better report of it in the supplemental bundle, but in the original bundle you can see it as a transcript, which was rather grainy on my copy 6236. And it was an application to stay a winding up petition. If you go to 6238, you can see, I think you can see somewhere there, the ground of the present petition is that it's just and equitable that the company be wound up. The grounds for the assertion appear to be that the petitioner and the applicant are in deadlock. Next paragraph, applicant moved for a stay on the grounds of the arbitration clause. And then at 6239, the judge says, this is a New Zealand case, by the way, 1977, counsel were unable to refer me to any authority directly in point where a similar position has been considered. However, I find the authority of greatest help to be the decision of Mr. Justice Roxburgh and Olver. Olver, not Oliver. And he then refers to what Mr. Justice Roxburgh says, and he says, I think that's a fair analogy in the present situation. The next paragraph, there's a power to wind up a company. It's a power specifically given to the court by the Act. It's not quite getting to the point I made on Section 92E, but it's close because he refers to Olver. And then 6125, which is a decision of the High Court in Ireland, Court of Appeal in Ireland.
It isn't only, I think, that the power is specifically given to the court. It's also that because the company is unlike a partnership, the company is a creature of legislation, and just as it can only be created in accordance with the legislation, it can only be dissolved in accordance with the legislation.
Yeah, and its death knell has to be dealt with under the legislation. That's the power point.
Yeah.
But the point I was making on Section 92E seems to be what Mr. Justice Kay had in mind in Joplin, which is what then is adopted by Mr. Justice Roxburgh. And if you go to the case in Ireland, the judge had refused to stay the matter, and then it goes to the Court of Appeal, and you can see the judgment starts at 6136 in the Chief Justice's judgment, and then on 6140, and I'm going to come back to this because it deals with the matter, but between letter D and E, you can see him referring to Olver. And then Simpson, who seems to have been a fairly able arbitration lawyer, given the submissions he's making here, envisaging some of the English cases that haven't been decided yet, refers to RSL, and I come to that on the question of matter. But the next 2 pages are instructive on that. The last case on this particular question is a case called 4 Pillars, which is at page 6254, Singapore case. The court holds that at 6259 that the arbitration, that the winding up was not within the scope of the arbitration clause. That's at let's say A to B. But it then also, at page 6260, refers to those 2 partnership cases that I mentioned to you. And then it relies on page, it also relies on a Manitoba case. But the point is that my learned friend says to you that all these cases have ignored my argument of construction, no one's ever considered it. I must be saying that all these other cases are wrong. There are a number of cases which, none of these were considered in the more modern cases. The argument wasn't considered in the more modern cases. In other words, there were authorities that would have been relevant to the arguments which were not looked at. And so we can't be criticised but for saying that all the cases are wrong when the later cases don't refer to the earlier cases which deal with the argument. Hydrox, I should just show you, because it does mention this argument. Hydrox is at 5690. You have it also in a supplemental bundle. I'm afraid I'm going to ask you to look at it at 5690. The argument that I made is, you can see covered at page 5711, paragraphs 112 and 113. And you can see the arguments at 112 and 113. It's pretty much the same argument. And the judge then says that's more question about arbitrability, paragraph 114. And then he deals with arbitrability at page 5712. And he doesn't return to this point at all and doesn't deal with the argument, and gets to 5721 at paragraph 164, which I showed you moments ago, where he seems to accept the proposition in the first sentence, by the first sentence, that the court has to deal with these things. And then says, 5721, paragraph 164, in the first sentence, he seems to accept that the court must form the opinion and so on. And then he says, well, the court can just take account of the awards in the next paragraph. But he doesn't dispute the argument of construction. And he seems to accept it, rather. Just generally on cases and winding up companies, the arbitrability of winding up companies, there's a well-known company case of Yaniji Tobacco, which was about is a joint venture between a Mr. Weinstein and Mr. Rothman, who stopped speaking to each other and would only speak to each other through the company secretaries. It was a case of deadlock. It's an interesting case for company lawyers because it's the first case that says it's not an aestem generis paragraph, You have it in a further supplemental bundle. I don't know if that's actually electronically reached you.
Yes, I think so.
Okay, it's the further supplemental bundle at tab 8, sorry, tab 7, page 82. And this is not anything more than a fairly old-fashioned example of arbitration being refused. At page, Lord Justice Warrington I think deals with it most clearly at page 91. There's only one other point. And cross-reference this to me. Yeah, well, that's probably all you need from that case. Early example of when it's discretionary stay at that stage. Fulham is really the next case on the arbitrability of winding up because of the obiter remarks. Our detailed submissions about Fulham are in our case. They're at pages 2102 to 2107. Between pages 2102 and 2103, paragraph 25, we draw attention to certain features of Fulham, one of which is that you couldn't have come up with just like this case in a way, you couldn't have come up with a more extreme example of something that's arbitrable. There was absolutely no difficulty in it because the remedy that the arbitrators had to give, or that was being sought, was one that under the rules the arbiter was already there. So it was common ground that the arbitrator could exercise those powers. There was no need to involve the state in exercising any powers. That was one point. It's all historic fact is another point. In a very narrow compass, the question was whether Sir David had been authorised to sell a gentleman called Crouch to Portsmouth Football Club. I don't know anything about football. I had to memorise that. It's not my sport. You can see from Mr. Justice Cabley that we were playing basketball and rugby, but football was not one of the things. And you can see that a very large number of cases have followed in from that part of our case. Very large number of cases have followed Fulham. That doesn't mean they're all right in following the obiter if the obiter isn't right. But they've adopted it fairly comprehensively. Quicksilver, for example, does that at 2104 and 5. Tomalugan follows Fulham without much comment. Not surprising because it's an unfair prejudice case. But it's given rise to, therefore, when cases follow after Fulham Football Club, they frequently don't add anything further to the debate. They can all be put in a schedule and you can be told that they're all terribly helpful and they haven't considered the points we raised, but almost all of them are heavily dependent on Fulham. The other point about Fulham is that Lord Justice Patten makes it clear that the case didn't involve, and the reason it went the way it did is because it didn't involve a winding up petition, a claim for a winding up petition. And the paragraphs in his judgment where he deals with this are 56, 58, 60, 76, and 77. They're dealt with they're set out in our case, so I'm not going to refer you to it. In Salford, that point is made by the Chancellor, then Mr. Etherton C, and it's page 4212 of the bundle. But I think that the reference again is in our case. I don't need to trouble you with it, because I'm just dealing with the cases that Malone and Friend relies on, so I'm giving you the points that I make in relation to those. There's a case called Consolidated Resources, which is a Jersey case at 6143.
Sorry, reference again?
A Jersey case called Consolidated Resources, a decision of Mr. Bompers, I think.
The page?
Oh, sorry, 6143.
Thank you very much.
Sorry. And the point about that is it was conceded that it was arbitrable in the light of Fulham at 6162, so that doesn't really get you very far. Hydrox, Malone Friend relies on heavily, also follows Fulham. You can see that at 5090. And I should also point out that the winding up in Australia is you can have a freestanding just and equitable winding up, but you can also wind up for oppression. And you can see in Hydrox that that claim is made for oppression at 2566. And then an alternative claim is brought for just and equitable. But the judge doesn't seem to then distinguish against it. And as I said, when you get to the final paragraph, he seems to have accepted the submission. Quicksilver, which is at 6090, it was conceded that the relief, it was held that the relief couldn't be granted by an arbitrator. I've given you the reference to that. That's paragraph 14 at 6098. And the issue in this case was about whether a shareholder agreement can be arbitrated, which in practical terms it obviously can be. It follows Fulham, as you can see in paragraph 15 on that page, 6098. It rejects the idea, which isn't an argument I'm making, that the just and equitable petition, winding up jurisdiction is about a class remedy, which it isn't in a contributories petition. That's at page 6099 to 6100, paragraph 17 to 19. And he says it doesn't affect any non-parties, which isn't a point I'm making to your lordships. There's another case called China-Europe, which is at 5991. These are the cases in Malone and Friend schedule, incidentally. That's a winding up case. It's another Hong Kong case. It was argued that that the winding up was a class remedy and affected third parties, and those were the only arguments that were made. The judge disagrees at 6036 to 6037, and at 6039 she follows Fulham. But you don't get anything from any of these cases because they don't deal with the arguments. They almost always take comfort from Fulham, which doesn't take the debate any further. And sometimes their legislation is different. Tomalugan, which is also in the schedule, is an unfair prejudice case and doesn't deal with the relevant thing. I'm not going to comment on Cyprus because Cyprus followed Fulham, or with great respect to Zambia, where Malone and Friend had some involvement, he told us, because again, it pretty much follows Fulham. They don't add anything to the debate before you. I'm not saying they're wrong in the way that they rely on Fulham, but they don't take the debate any further. So I was now going to turn, those are the cases on just and equitable arbitrability. They're the cases in the schedule and the cases that went in the schedule, which we say are the cases where the arguments of construction were accepted.
And the upshot, as I understand it, is that the court can take into account matters which are agreed between the parties in a two-party dispute, but ultimately it has to make its own mind up.
Well, no, can I put it rather differently? I was going to summarise where I got to.
Please, thank you.
The upshot of the cases is they really don't help you very much. You can see that the argument of construction has troubled judges in the past, in the partnership cases. It's relied on in Northern Ireland and other cases. So you can see the argument of construction I put to you isn't completely off the wall. I didn't come up with it myself. That's what I'm trying to say. The other cases that Malone and Friend relies on don't really take matters very far because they don't go much beyond Fulham. So the cases don't help you. You've really got a pretty blank sheet when you look at this. You can say that some of the cases, go one way or the other, but they don't really take, in terms of reasoning, don't take things further. Learned Friend relied on them to say, well, I have to say they're all wrong. And none of them have, all of them are wrong because they haven't considered this wacky point we've made. And that my purpose of showing the cases was simply to deal with that submission. I made my submissions on construction. You have a pretty clean sheet to deal with that, apart from the Court of Appeal. Does that make sense? I don't know. Sorry, I shouldn't ask you questions. I was trying to answer my Lord Kitchen's question.
One thing that troubles me a little bit is that the older cases to which you've been referring us, like Olver, are all discretionary stay cases. They must be, because the mandatory stay doesn't come in until...
96.
Yeah. I mean, speaking for myself, it's obvious why one might well refuse a discretionary stay, because of the procedural inconvenience, to put it at its very lowest, of having one tribunal find all the facts and another tribunal make all the key analytical decisions and grant the order.
Yeah.
So that anyone with a mind to avoiding circuitry of action and expense and delay would say, no stay.
Mm-hmm.
But none of those cases address the remorselessness of the mandatory stay if, A, it's within scope, and B, it's arbitrable.
That's all about the matter again, yeah. But I mean, it's the reason for showing you Olver and Mr. Justice Kane isn't because you see the courts when it gets to the Court of Appeal, and there's another Court of Appeal, they deal with it as a matter of discretion, just as you ought to. But Mr. Justice Kay and Mr. Justice Roxburgh clearly had a point about the construction.
Of the Act.
Of the Act.
Yes.
Because they
But
may
it's
not,
ultimately for the court to decide.
yeah.
Yes.
So that the reason I was relying on them is because that's the point of construction I was making.
Yes.
So can I deal with bifurcation, which gets me to matter? Because that's really the rest of most of my submissions are. Is that 12? Okay. Did you want to? I can't remember whether you wanted to break in the morning because no.
No, we're content to carry on. Thank you, Mr. Lowe.
And I wanted to start the discussion about the matter, introduce it by reference to bifurcation. Because a pro tanto stay works, obviously, when you have claims which are covered by an arbitration agreement and some which aren't. Then you have a pro tanto stay. You can have a pro tanto stay when there are some parties that are subject to the agreement, some aren't. That's another obvious example. Fulham and Lombard after it applied pro tanto stays by passing up a single claim, which is a bit more controversial because it means that you've got several matters within that claim that you can pass up. Fulham deals with this at paragraph 83. I'm not going to take you to it now, but I'd like to show you Canning. I know you saw the quote, but the quote is important. If you go to page 5670.
567.
5670, sorry.
Thank you.
The actual beginning of the report is 5651. And it was about a proof of debt. And the relevant passage, as I said, was 5670. And as my Lord Reed pointed out to my learned friend, my learned friend was focusing, and some of the other cases have focused on the dichotomy, as Tom O'Lugan says, between a discrete issue and a controversy. But actually, if you read the sentence that precedes it, in the quotation on 5670, the last paragraph, halfway down, even so, the expression matter capable of settlement by arbitration, and we'll come back to settlement, indicates something more than a mere issue, which might fall for decision in the court proceedings, or might fall for decision arbitrable proceedings if they were instituted. It requires that there be some subject matter, some right or liability in controversy, which if not coextensive with the subject matter of the proceedings, is at least susceptible of settlement as a discrete controversy. Settlement, I suggest, means being concluded by agreement or by decision. The reference to subject matter and some right or liability in controversy is much broader, looks at the matter much more broadly than Mozambique. And the subject matter, I will say, of a winding up petition is whether it's just and equitable to wind up a company. That is the question which you'd have to compromise. In a case called Reinhardt, which is at page 5503, to the 2019 High Court of Australia case.
Reference again, please.
5503.
Thank you.
This case concerned the question whether you were claiming through or under another party, which is another phrase in the section. And the relevant passage where they adopt the minority judgment at this level of court is 5530. They cite without negative comment. And in all other, as my learned friend accepts it, that everywhere else in Australia that is.
So what are we looking at?
I merely wanted to show you in Reinhardt, which is a recent, very recent High Court of Australia case, that they adopt the minority statement. Remember, it's a minority statement in Tanning. They adopt the same statement at 5530. They deal with it without comment, but they, well, without real comment, it's at the top of the paragraph.
What year are we in? Oh, 2019?
Yeah.
Yeah.
So obviously the key place I want you to look is 5670, and particularly that phrase. We then get to the Hydrox case, which is at 5690, 2016, and how that deals with matter, because that becomes relevant to the Court of Appeal in Tomalugan. And he starts dealing with that at 5709. He says at paragraph 105, word matter is not used in the constitutional sense, see Tanning. Ordinarily, 106, the nature and extent of the matters involved in the court proceeding are to be ascertained from pleadings. Well, that's not rocket science. As Dean and Gaudron said in Tanning, the inquiry is to ascertain the substance of the controversy between the parties in the court proceedings, or as submitted by Woolworth, the substantive questions in dispute. Not necessarily as the ultimate, same as the ultimate questions. And he says the matters to be determined in any proceedings distinct from the proceedings themselves. There could be multiple matters. He then sets out the passage in Tanning, and then he goes at page 5711. He says a matter can be the whole of proceedings or not. It's more than a mere issue. And then, if you look at, you're going to find it difficult to see him then formulating or referring to the test of that one sentence in Tanning that we looked at. And he says, says, in my view, paragraph 122, this is where he, having recited the text and not set out the test, he then says at 122, in my view, there are several matters involved in the present proceedings. And there's no explanation of how that works under the test. He just comes up with what he feels the matters are. He takes what is described in Tomalugan as a granular view of the case, but doesn't actually explain how this is the subject matter, the right or liability capable of settlement, which is the critical sentence. And what he seems to do in paragraph 122 is completely heretical, like I was yesterday. I mean, still am. The matters that he then sets out are issues, broad issues. But nowhere in Tanning does he get that, nowhere in Tanning is that the test. We then get to Tomalugan, which is 6653.
But in his earlier discussion in 106, 107 and 110,
Yeah.
he seems to be quite clearly saying that there is a difference between matter and the whole subject matter of the proceeding, and it seems to be suggesting that you can subdivide, whether in a granular way or not, you can subdivide the whole subject matter into separate matters. That seems to be his reasoning, which doesn't make his conclusion in 122 necessarily surprising.
No, it's inconsistent, though, isn't it, with what is said in Tanning, which is that it's the subject matter, right or liability, that is the matter. And what he says, it's the subject matter can have several matters. And he gets that from nowhere. And then when he gets to deciding what the several matters are, in paragraph 122, he's passed up. And of course, remember, he's dealing with an unfair prejudice complaint, so that might be why it's different. But he passes it up. He's not dealing with the question under section 92E, one question. He's dealing with a complaint which maybe can be passed up this way. But the point in Tanning is that you're looking for the subject matter, the right or liability capable of settlement. And he should have really been directing himself to that as a test. And that is recited subsequently by the High Court of Australia without any question as the relevant passage.
Again, I think a subject matter which is a right or liability which is capable of determination may be a component part of an overall assessment of a just and equitable winding up, for example. One could have a ruling, a declaration by an arbitrator that one or other of the joint venturers had breached the shareholders' agreement. And that could be resolved by arbitration, and that would be a component that would go into the assessment of the just and equitable winding up.
Yeah, with respect, my lord, that's the tail wagging the dog, because you've got to decide first what the matter is. And of course, if you decide it's capable of being decided, and therefore it's a matter, then then you're always going to have a self-fulfilling answer to that.
Well, but your position with respect to is mere assertion that the only subject matter of a just and equitable winding up is whether it's just and equitable to wind up. Well, I don't think, with respect on my reading of Tanning, it is going anything like that far.
Well, I see what your lordship's putting to me. What I'm submitting to your lordship is that the subject matter of a winding up, just and equitable winding up petition is whether it's just and equitable to wind up the company. I have got one case in my favour, which I'll show you, but my submission is that is how you should look at matter.
Yes, thank you.
The way it was put by the judges, the majority judges in Reinhardt at 5530 is perhaps helpful. In the question was whether matters raised in the defence were capable of resolution by arbitration. And they say in the first paragraph, before they turn to Tanning itself, that it's unnecessary that the issues that the defence puts in controversy in the proceedings, so in our context that would be the winding up proceedings, be limited to the matter capable of settlement by arbitration. The two need not be coextensive. It's sufficient that the defence puts in issue, among other things, some right or liability which is susceptible of settlement under the arbitration agreement as a discrete controversy. And that would seem to be consistent with the point that my Lord was putting to you a moment ago.
But yes, but I mean, leaving aside the understanding, the breach of which looks like an agreement, but it's not. Leaving aside that, the question of lack of probity, which is a way of proving just and equitable, is not a right or liability that you can settle. And so I can understand, because the understanding is such an obvious thing that looks like a contract, why if you put that to me, I'm going to have real difficulty. But with the lack of probity, that's quite different. That's just an incident of just and equitable. And
well, so, could one not break it down a bit? I mean, here the lack of probity is that's alleged is it not a breach of fiduciary duty on the part of the directors?
Yes, but if you look at remember that if you do it without the benefit of the understanding, it has to rise to a level of lack of probity, which gives rise to justifiable loss of confidence. That's the wording in Locke and John Blackwood. So that's really what you have to prove to get home on just and equitable. That doesn't look like a right on its own. That's something what is the real question is whether it's just and equitable. And the Westbourne Gallery type of arrangement is in truth the same thing. If you treat it like a contract, you can see it as a right, but it really is not quite that. It's an equitable. These are equitable considerations that are superimposed. So in reality, these are facts that you use to prove that it's just and equitable, and that's the subject matter of the proceedings. That's my submission, for better or for worse. Can I just show you? This does go, however. I mean, there's the point whether or not you can break down tanning. I say tanning makes a difference to this case for the reasons I've outlined. I'm going to come back to that in a moment. But the way in which it then develops through Tomalugan, which is, I think, just 6653. 6653.
Thank you.
I'm really just putting it to myself to make sure I'm getting the point, but you're saying you wouldn't arbitrate over a fact because what's the point of having an arbitration about a fact? You would submit to arbitration. The submission to arbitration would be of some dispute over either one party's rights or another party's liabilities.
Yeah.
And so you're looking to see whether there is, if you're applying Reinhardt and Tanning, you're looking to see whether the dispute before the court contains within it disputes of a nature which could be realistically submitted to arbitration.
Well, you have to adopt a test for matter, and I'll come in a moment to the question of maybe the best approach to that. I just really wanted to cover the cases so you can see what they say.
Right.
And then I make some submissions about them, if you don't mind. Tomalugan, which I think starts dealing with this at page 6653.
Yeah.
I can skip over to the next page, 6654. You get to paragraph 111, the question of methodology. And then at 6655, they recite paragraph 112, the prevailing test in Australia, where they've missed out in the first sentence subject matter. But they otherwise say that. And then they, in the next sentence, however, is really a non sequitur. A mere issue wouldn't suffice. The dichotomy between discrete controversy and mere issue was articulated in the joint dissent. Well, that's sort of missing the point. The point in Tanning, which I may have overstated, that's a separate question, is that sentence. What they then go on to say is that it's about discrete controversy is yet another test. What's a discrete controversy? And that isn't a fair summary of the proposition in Tanning. And then we get to 113, where they say 5 lines up, in our judgment, when the court considers whether any matter is covered by the arbitration clause, it should undertake a practical common sense inquiry in relation to any reasonably substantial issue, which I remember Lord Kitchen put to my learned friend yesterday as something that's quite difficult to understand. What does it mean? And then they say, in most cases, and this is also quite hard to follow, because in this case it would mean what I've submitted. The matter would encompass the claims made in the proceedings. That's not an inflexible rule on page 6656. So on the face of it, it's quite hard to see if it's that, the matter is that broad, then it's fairly similar to what I was submitting was the outcome of Tanning. But the discussion doesn't really seem to bear that out. And then the next paragraph, semantic distinction between, they return to this semantic distinction, which is, they say, illusory, but that isn't really what the court, the dissenting judges in Tanning were saying. And then if you go to go to page 6657, they then seem to look at the granular approach in another case called Trident. And on 6659, oh, sorry, you were shown a passage on 6658 in paragraph 121, characterising a matter an unduly high degree of abstraction may carry with it the elegance of simplicity and convenience, but any attempt to boil down a complex dispute to a singular aspect of its essence would be contrived. I'm not sure that really helps in interpreting matter. And 6659, paragraph 122, shouldn't construe it either overly broad or unduly narrow. I'm not sure how you go about doing that. The specific facts of this case, the 4 categories of allegations raise substantial issues, neither peripheral nor tangential. We find them all matters. I'm not sure anything really helps you get to that point from any proposition of law that they've come up with.
Mr. Lowe, this whole debate about what matter means for present purposes is all aimed at the question, isn't it, whether something which is all or part of the winding up proceedings is within the scope of the arbitration clause. Now, in the statement of facts, the agreed statement of facts and issues, it records that the scope question was abandoned during the hearing in the Court of Appeal. Is that just a mistake?
No, the matter. Remember, the matter is what you've got to identify for the purpose of Section 4.
Yes.
So I accepted that the disputes, as a matter of construction, fall within the clause because of the breadth of the approach to construction. And Mr. Justice of Appeal Ricks bullied me into that. But
But if
Quite
it's within,
apart
but,
from
I
that.
mean, this isn't about arbitrability, as I understand it. This is entirely about whether the matter which the party wants to litigate is or includes something that is within the scope of the arbitration agreement. It's not, it's, I mean,
Not
the
quite,
statement of
but-
facts and issues said there were two issues before the Court of Appeal, whether the underlying facts were within scope, and if so, whether they were arbitrable.
In this case, in
Yes.
Tom Malugan, yeah.
Yes. No, in our case.
In our case, yeah. But also, the question is whether or not they come within Section 4 to get a stay. So they have to show that they get a stay in respect of a matter, and we say that matter is not arbitrable. Because
Even
it's
though
one
it's
matter.
within the...
Because it's one matter, and that parts of that matter are not arbitrable.
Is this only an arbitrability dispute?
This is an arbitrability dispute, because it gets to be an arbitrability dispute because of the debate we had earlier, that I can't say, if you pass up the dispute, that the individual parts of the dispute, matters 1 to 3 or whatever they are per se non-arbitrable. What I say is that the matter is whether it's just and equitable to wind up the company. And that is, in 2 respects, non-arbitrable. And so the whole matter can't be, none of that matter can be arbitrated. It's not arbitrable.
Yes, I mean, the key point, I think, is that you cannot subdivide.
Exactly.
You cannot subdivide a just and equitable winding up. You say there is one indivisible matter for the court to address.
Yeah, as Lord Lloyd Jones pointed out to me, that was the submission. You cannot subdivide this in different components and then say that you arbitrate 2 or 3, but not.
I struggle to see why that is consistent with Tanning.
Well, that's a different question. I'm all out at the
Well,
moment.
is it? Because
No. Sorry. At the moment, I've been trying different to what I've been addressing. I'm just showing you the cases, and I'm going to show you that the cases post Tanning don't really address the Tanning argument. They don't really come up with a rational test of their own. And when I come to make submissions about what a matter is, you'll see how I get that back to Tanning, okay? Or my interpretation of Tanning. The Tom Malugan, I've shown you. There's a case in England, the next case really that deals with this is a case called Lombard, a decision of Andrew Smith. At page 3887 is the front of the case, and the relevant passage is at 3893, paragraph 14. Tanning wasn't cited, and the judge says there's no judicial authority of which counsel I know that directly considers the meaning of in respect of in section 9.1 or how the court determines whether proceedings are in respect of a referred matter. The question, of course, depends on the nature of the claims, but not, I think, only on the formulation that would allow the claimant to circumvent arbitration, which is what the judge accused us of. In written submissions, Hapgood referred to the purpose for which Lombard seeks the declaration. He didn't seek an oral argument. He did not suggest an oral argument. The claimant's subjective purpose in bringing proceedings is relevant. It seems to me that, in this paragraph 15, if the parties have agreed to refer a matter to arbitration, a party so wishes should be entitled to have the agreement upheld. The principle underlying the act. So what he's doing is he's saying, well, if you've agreed it, it's a matter. But that's not how it starts in Tanning. There has to be a test, otherwise the answer is always that you arbitrate. You know, the tail is always wagging the dog in that case. If the parties, if whatever the parties agree is a matter, then you're always going to pass up that matter and say it's arbitrable. And he says at the bottom, although Lord Justice Patten said that Section 9 is concerned only to identify the existence of an agreement which in terms covers the matters. The section refers to a matter in dispute, not the matters. And he said, so that's where he gets to, but he doesn't do it by reference to any authority. And then the next case is Mr. Justice Popplewell, which, as you know, gets transposed into Mozambique. And he deals with it at page 4228. And he adopts, remember his proposition is any issue and all issues. 4215, 4228.
Yes, paragraph 43.
Yeah, thank you. Thank you. And Mozambique, you remember, adopts this as the test. So you've gone from tanning, which has what we've seen, to a test which is extreme, where it's any and all issues, which is what Mr. Justice Popplewell finds, and which then goes into the Court of Appeal judgment. Now, that's where the authorities get you to. Focusing on the subject matter, right or liability, in the way that we've done, means that fragmentation will be limited. This is consistent, we say, with the expectations of rational businessmen. The idea of a one-stop shop is promoted by that. It's consistent with Fiona Trust to give this a broader interpretation, just as in tanning. And it's hardly revolutionary, given that whatever tanning really means is followed in at least one major jurisdiction. Tomalugan came up with its own test, and the English test, which is now seems to be the final position in Mozambique, means that you're going to have extreme fragmentation, because any issue in proceedings can be arbitrated. If you have anything that is capable of being arbitrated, you're going to send it off to arbitration. And that either means that this only arises when the whole claim, when there's something in the claim that can't be arbitrated. But by allowing parties to pass up any issues, you create a high degree of fragmentation, or a potential for high degree. And it's not promoting a one-stop shop or meeting the expectations of businessmen. I mean, you think about the expectations of businessmen. They would prefer not having fragmentation. They would prefer having something that would promote the one-stop shop. And so we say our interpretation of tanning is consistent with that. And the eagerness to have something arbitrated rather than nothing arbitrated, which is the UK approach, is contrary to the objects of an arbitration. And that's why I showed you Section 3 of the Act, subsection 3. The object of arbitration is to obtain a fair resolution of disputes by an impartial arbitral tribunal without undue delay or undue expense. If that can't be done, you're not meeting the objects of arbitration. The reference to that is page 2166 in our arbitration law, but it's also in the 1996 Act in England. So we say our approach to determining what the matter is consistent with those principles. Does it make a difference to our case? We say yes. We say yes because and we dealt with this in our case at pages 2131 to 2, paragraph 97, which is where we set out why the matter that you could compromise effectively is whether it's just and equitable subject matter. There's the case of Wine Inns, which I promised I'd take you back to, is 6125. And the Court of Appeal in Ireland dealt with a winding up petition in this way, 6140. You have Simpson, just by letter E, advancing the argument that if the parties agreed under Clause 10 to submit all disputes to arbitration and by parity of reasoning with RSAL, they took the consequence that they could obtain only such relief as fell within the jurisdiction of the arbitrator to grant. In this court, Simpson stated he hadn't intended to put forward that argument. He submitted that the matter didn't constitute a single dispute, but a series of discrete disputes of differences over the matters set out in the winding up petition, that each should be referred to arbitration. The arbitrator or arbitrators should then receive the evidence about these matters and reach findings of fact on each, whereupon the matter could come back to the court for the judge to decide on the basis of the arbitrator's conclusions whether to make a winding up order or to grant a remedy under 452. It appeared to follow from his argument the petitioner would have the right to come back to the court after the conclusion of the arbitration process and would not require the consent of the respondents to the petition. Complexity and inconvenience of such a procedure, and so on, that's procedural complexity. And he says at 6141, this is the Chief Justice in the Court of Appeal, we don't find it necessary to express an opinion on how such procedural difficulties might be surmounted, because we're of the opinion that the appeal is concluded in favour of the respondent by the construction of Clause 10 of the agreement. We're unable to agree that the matter's indifference consisted of a series of discrete disputes, as Simpson contended. In our view, there were but two issues between the parties. A, whether it was just and equitable the company would be wound up, and B, whether the company's affairs had been conducted in a manner which was unfairly prejudicial to the interests of the respondent. Complaints set out in detail in the petition are facta probandia, which matters which, if proved, go towards establishing the facta probanda, so the evidence which proves the fact you have to prove. The two issues to which we have referred. Now, I see that he deals with it as a question of construction of the arbitration clause. That's the point Lord Briggs was putting to me earlier. But the point is, he still has to. I mean, I don't know what the Irish Arbitration Act says, but you still got to get through the Foreign Arbitration Awards Enforcement Act, which refers to staying a matter. And so whether it's within the arbitration clause doesn't resolve the question whether it's a matter. You have to have a test for what the matter is. And the test that the High Court of Australia came up with, we say, is the correct one because it's the most business-orientated one. It promotes arbitration. It will give it a better name if there isn't fragmentation. We're not the anti-arbitration lawyers at this point. Anyway, right. So that's the other point about this is it arises from the question of settlement. You remember, it's a matter that can be settled. That's the wording in the statute. That means it's not just a compromise alone, but something that can be concluded by decision, that the parties can agree can be concluded by decision. So that suggests that the arbitrator must be able to bring a dispute to an end by decision. And if the arbitrator decides, we say, for the purpose of these purposes, matters 1 and 2 have Ting Chuan acted contrary to the undertaking, have the directors breached their duty, he can't actually finally decide those. He can't end them because the court still has to evaluate them. So it's not a matter capable of settlement to say that the understanding isn't a matter capable of settlement because the arbitrator can't then make a final decision and the breaches of duty are, because the issue, the matter then still has to go back for the court to decide before it's ended whether it's just and equitable. And on further evidence.
Capable of settlement could mean two different things.
Mm-hmm. Yeah.
It could mean capable of going all the way in the arbitration process to a remedy.
Yeah.
Or it could mean that a matter in dispute did something happen or didn't it happen, was there a breach or wasn't there a breach, has been finally determined in a way that binds the parties without prejudice to what remedies or consequences may flow from that.
Yeah, I mean, it looks like it could, yes, it could mean that it's something that the parties could agree, i.e. settle between themselves, a right or liability or subject matter that they could agree to settle, or that they could agree to give to someone to decide for them. But the question, the arbitrator can never end those disputes because they always come back on further facts to the court. You know, they've done it again.
Yes, but that's just another way of saying the arbitrator can't can't resolve the just and equitable winding up. But if an arbitrator can make a declaration that there's been a breach of the shareholders' agreement, or can find that there has been a departure by one or other party from the equitable constraints by which it should be governed, that those issues as such are resolved. And in the arbitration agreement, I think there is a provision for a share buyout, for example. I mean, an arbitrator can make a ruling on that as well.
Yeah.
But the fact that you can't go further and make a just and equitable winding up order, or on your submission, I see the force of it, form an opinion whether it is just and equitable to wind up, doesn't mean that there aren't matters resolved by the arbitrator.
No, the question, no, I mean, if you look at matters as a subject matter or a right or issue, then the question is whether you have to stay the parts of the petition. It's not whether they can in fact be done. The question is whether you stay part of the petition, and you have to have a test for what is the matter. That's all I submitted, and there has to be a test. English test is that it's any issue, and the Australian test clearly isn't. And I'm inviting you to adopt the Australian test because it's more business focused, makes more sense. Does that help me? I say it does, because the only subject matter of a petition is whether it's just and equitable. And if your Lordship put to me on a number of occasions the understanding, and I can see, because it's so close to a contract, that looks like the subject matter. But actually, if you start with the other complaint we've got, which is our lack of probity, giving rise to justifiable loss of confidence, much more difficult to see that's anything other than just and equitable. And if you once you recognise that and remember that Westbourne Gowrie is just an equitable gloss on the situation, it's really the same thing. It's not a contract. And that's why we say the matter, in our case, is the winding up petition, the just and equitable ground. That's the matter. And that can't be arbitrated, because so much of it has to be done by the court.
If one tries to apply tanning, you could see that if there were pleadings in the winding up petition, there might be a whole series of averments that were disputed. For example, was the director, the Japanese director who went to Shanghai, was he denied access to the documents that he wanted to see? That might be in dispute, who knows? But that, I think, would be what in Tanning was described as a mere issue. Whereas the question that might be submitted to an arbitration would be put at a higher level of generality and by reference to people's duties. You know, was there for example, a breach of the of the understanding that's pleaded. One can imagine under the arbitration agreement, one can imagine an arbitration about an issue about a question like that. And so Tanning might, if one adopts the Tanning and Reinhardt approach, one isn't left with a sort of all or nothing. One might take the view that there were matters that clearly statutorily can't be determined by arbitration, just non-arbitrable. But at the matter stage, the Tanning approach could help you to formulate what the relevant questions that are arbitrable are.
Yeah, but I mean, that gets very close to looking at issues and looking at it in terms of the Mozambique test.
Well, that's what I'm trying to avoid by saying if you look at every averment of fact, for example, that's in dispute, you could say every one of it is an issue. You could have an arbitration on every one of them. Yeah. But and if there's another fact that emerges between the date of the arbitral award and the date of the hearing in the court, then you could have another arbitration about that. So, but if you're following the High Court of Australia approach, then I think you're identifying matters that are arbitrable at a higher level than that, by reference to people's to the parties' rights and obligations, as it's put.
Well, the thing is that the rights and obligations in a just and equitable petition are not. They're not like normal rights and obligations. The lack of probity, for example, is not a... It's very difficult to look at that as a right. I think Lord Briggs struggled a bit yesterday. He said mentally with the idea that there were rights or liabilities before we looked at subject matter in the petition, because you can't really see that. You can see it's the subject matter, what the subject matter is. And if you leave out, for example, for the moment, and this might become relevant because of the company's position on the stay. If you leave out for the moment that there's an understanding and you focus on justifiable loss of confidence or lack of probity, we say that has to be one issue, one matter. And the reason it has to be one matter partly can be explained by what happens where, imagine it was decided and then we have them doing it again after the award. Is that a separate matter? Because it would have to be, if it goes back to arbitration, you'd have to stay the petition. Or isn't it all part of still the same matter that should have not been arbitrated at all? And we don't have that problem if we take the matter to be whether it's just and equitable to wind up the company under ground E. Because we don't get to a point where the arbitrator decides something and then another matter would appear afterwards. And the further facts post-petition aren't separate matters. They all still go to the same question. But if you look at it in terms of separate issues, you'll say immediately after the award, doing it again has to go back to arbitration. And you have no discretion. It has to go back to arbitration because it's yet a further matter.
Well, for example, rather than having an arbitration about individual allegations of, an allegation of lack of probity, one might say, applying Tanning, that the relevant matter would be in an arbitration between the shareholders whether the Chinese shareholder had procured breaches of fiduciary duty or misconduct on the part of directors of the company.
Yeah, I mean, that is, of course, it would be misconduct by the other shareholder.
Yeah.
And the question would be whether, in its totality, I mean, you could decide it in my favour by saying that's so heinous that on its own that's gross, that's lack of probity, and you can lose confidence. Or, more likely, you would say, well, we have to look at the conduct of the directors and see whether or not that all adds up to lack of probity. So you can't pass it up like that again, because you're going to always look at lack of probity more generally. I mean, if you look at Locke and John Blackwood, there were allegations that there hadn't been any directors' meetings, that there had been that no accounts had been filed, and so on. All these technical breaches, and then I think he was the brother-in-law, did something really bad with the plantation. He just shunted it off into another company. So it was really bad behaviour towards the end of the relationship. And it's possible that all of it together amounted to the lack of probity in which you lost confidence, or only one of the events. It's difficult to say. Very difficult to tell on the judgment. So that's my submission. If you look at Fulham, when you're looking at matter or whatever it is, remember that they're dealing with a historic fact. There's nothing further that happens. He sold Crouch to Portsmouth. The question was whether he's authorised. It's a historic fact. Oh, Spurs, I'm told. I don't know where Spurs is. I'm really sorry. I'm showing my ignorance.
Tottenham.
Not my field. And in Bridge House, the relief that was sought, if you remember, you asked me, a friend to show you this on another occasion, is whether the contract was revived after dissolution and the restoration of the company. But again, it's by reference to historic fact. It's not like a winding up petition. It's not like a just an extra petition. I was going to then turn. What's the time? I've got to deal with remedial impotence, I call it, and procedural chaos, which I'll do after the break, if that's convenient. And I was going to deal with the question of the stay in relation to the company that isn't part of the arbitration agreement. But I'm making good progress, if that's anything. Sorry, if it is for your lordship, yeah.